afternoon. Our next case is Smith Debnam versus Muntjan, and we will hear from the appellant.
Good afternoon, Mr. Chief Justice, Associate Justices, and may it please the Court. My name is Joe Davies, and I'm here on behalf of my law firm, Smith, Debnam, Narron, Drake, St. Sing, and Myers, the plaintiff in the trial below. With the Court's approval, I'd like to reserve 5 minutes of my time for rebuttal. Simply put, the question before this Court is how specific a memorandum or a note of an oral agreement must be in order to make a promise to pay the debts of a third party enforceable under the statute of frauds. This is not a question the Court has to decide often, as indicated by the age of many of the cases cited by both parties, as well as by the Court of Appeals. And even in many of those cases, the main issue is whether the promise was original or collateral, meaning whether the statute of frauds even applied. The panel below agreed that this was a collateral promise, making the statute applicable. In many of the other cases cited in the opinion below and in Mr. Muntjan's brief to this Court, the underlying contract that was sought to be proved was something other than a guarantee, typically the sale of real property, which requires much more specificity than an oral promise to pay the debt of another, or the written memorandum requires much more specificity. In those cases that do involve guarantees were all decided long before the pervasive use of email in business transactions, which it's often less formal style. However, as the Court of Appeals has previously noted, a memorandum under the statute of frauds is informal by its very nature. In this case, following a meeting at which Paul Muntjan orally promised to pay Smith Debnam for its work performed on behalf of his son Nick and a company called Triangle Home Remodeling, Paul sent an email to Smith Debnam partner Byron St. Sing in which he made the following relevant statements. Received your email as addressed to son Nick regarding the case and request for prompt payment. Rest assured your invoice will be turned around immediately and a check sent upon receipt. Please note as of this date, no invoice has been received. Please ensure any and all invoices are sent to my email due to my travel schedule. And below, there was a discussion of the applicability of the Winders versus Hill case, but the real dispute between the majority and the dissent was whether the language in that email was sufficient to memorialize a promise by Paul to pay Nick's debts. The majority decided it was not, while the dissent would have held the opposite. The key case appears to be, yet another old one, the Fain grocery case from 1921. In that case, this Court noted the difference between effectively vouching for a third party, saying that they pay their debts on time, or if you extend credit, I believe they will pay you, versus actually agreeing to be bound for that party's debts. And in that opinion, this Court noted that in order to be held liable for a third party's debts, the would-be guarantor must, quote, manifest a clear intention to bind himself for that debt in some written form. And in that case, the purported guarantee was nothing more than the opinion that the third party would pay all just claims against them. The question before this Court is whether Paul Muntjan's email from September 2019 was simply an expression of Nick's likelihood of paying, or whether it manifested a clear intention to bind himself for his son's debt.
Is the email ambiguous?
I don't believe it is ambiguous, Your Honor. I think that there is language within the email that Paul Muntjan would have you believe was just referring to, his family's general practice of, paying their debts quickly. But again, it's coming from a single person saying, while it does have that language of it's our, I don't think policy is quite the right word, but it's our practice to pay our valued partners quickly.
I'm sorry.
The rest of it is rest assured your invoices will be paid upon receipt.
I guess what I'm trying to get at is, if we disagree with you and we think it is ambiguous, would it satisfy the clear intention standard in Fain, or would we have to say there's no clear intention here?
Well, I think that I would say that if something establishes a clear intention, it can't be ambiguous.
And so
You
if
know,
it's ambiguous, then
and so if it's ambiguous as to what his intent was, then I don't think that you could make a finding that the intention was clearly manifested.
okay.
But I also think that, again, the distinction that the Fane Court draws between, you know, kind of vouching for somebody else versus saying, I will pay this debt, you've got a kind of a range, right? And the question is, where in that range does this email fall? And I think as the dissent below noted, I think it clearly falls on the line, on the side of, I will pay this debt. It says, I haven't gotten it, there's been no invoice received yet. As soon as one is received, a check will be sent. And by the way, please make sure all the invoices come to me. And so I think that's a clear manifestation of an intent that he was going to be the one paying those bills.
So the Court of Appeals majority, in a footnote, said defendant's writings plainly imply that he would pay Nick's debt, but his writings do not say so. Is that what we're really trying to decide? Is the implication sufficient to bind him on these contracts?
Well,
on this contract?
I think that's one way of looking at it. I think another way, Your Honor, is to say, does the language of that email actually go beyond just a mere implication, as the dissent determined? And I believe also in that same footnote, the majority says something along the lines of, all that was necessary was an email saying, I promise to pay my son's debt. But the Court of Appeals has also previously indicated that a memorandum does not have to be in any particular form. And to require a guarantee to pay the debt of another to say, I promise to pay X's debts, is doing exactly that. It is saying the only writing that will satisfy that is this particular turn of phrase. And the statute's clear that it is the writing or some memorandum or note thereof.
There's a difference, though, between saying that a document can be informal and saying that no express promise is required. You can have an express promise informally stated, but that doesn't mean that it's not there or that it's not required.
I think I understand what Your Honor's point, meaning that you could have an a writing on a napkin would be a writing in an informal setting that would have specific language that would manifest that promise. Is that where you're?
Well, I guess isn't the key question whether an express promise to pay is required or whether an implied promise is enough?
Well, I think that's the question of whether the note or the memorandum, and again, this is, I believe, the Hurdle case from the Court of Appeals, where the language that they used was the writing is not the contract. It's the admission that the contract was made. Here, there is a finding of fact that Paul made an oral promise to pay these debts. And so the writing, the email then is the admission, the note or memorandum that admits that he had made that promise. And whether the language in the email itself, I think, again, manifests that clear intent that he was going to be the one to pay. I don't think the statute of frauds requires an explicit promise. Again, the Fane case says all that's required is a clear manifestation of the intent to be bound.
The trial court found, finding of fact 3, that Paul promised to pay for plaintiff's services rendered to Nick and his company. Court finds the testimony about that to be credible. And then it says in finding of fact 4, plaintiff prepared and delivered a proposed engagement agreement addressed to both Nick and Paul. How many of these circumstances, if any, should the court look at to determine whether there's more than just an implication that there was a promise to pay? For example, the use of the credit cards and other correspondence between the parties.
I think I'll answer that in two different ways. In terms of whether the guarantee passes the statute of frauds, I'm not sure that the court can look much beyond the writing itself. Because as my colleague pointed out in the brief, at some point there has to be something you can point to that says that's the writing. And we think that email from September of 2019 does that sufficiently. The dissent below noted that the other emails also kind of manifest that same intent, and I think where the court can look at those is to determine whether this was a one-time guarantee of, you've asked for payment of this invoice, send it to me and I'll pay it, versus the ongoing nature of a continuing guarantee. And I think the court in the Hickory Novelty case outlined what can be determined or what can be considered in determining whether the guarantee is a singular one or ongoing. And I think that's where you can look at the surrounding circumstances, the additional emails of where he's not only were the payments made using his credit card, but he was following up asking about the status of the account, particular missed payments. I think that shows that he had an intent the whole time to be the one making these payments.
So what if what happened in this case was the father and son get the proposed engagement letter, and the father looks at it and says, whoa, what's this guarantor? I'm not doing that. Look, son, I know this is going to be tough paying these legal bills, so I'm going to pay them when I can, but I'm not promising that if you don't pay, I'll pay. I'm just going to step in and pay some right now because I have money you don't. Who knows what's going on behind the scenes here, but would you agree that you could do that? Someone could just step in and say, I'm going to pay for a debt that you've incurred right now, but I'm not, in doing so, making any commitment that I'll always do so in the future. And I think my question is, how can we see from what's in writing here that it's your position and not that?
I think the primary way is the hypothetical Your Honor lays out is between the father and the son. I'll pay this now, but I'm not promising anybody else that I'm going to pay him down the road. Here we have an email from the father to the law firm, the one that was providing the services, saying, send me these invoices going forward. A check will be sent as soon as an invoice is received. So I think that's one distinction. With regard to the engagement agreement, there is no question that we all wish that engagement agreement had been returned signed. And there's the transcript is clear that at the initial meeting, Mr. Saint Singh believed that the father had some interest in the business as well. And so he was requiring basically everybody connected to the business to agree to pay for those debts.
But aren't you asking us to pile on inferences? So we're supposed to infer from this email that a promise from the father to pay the particular payment at issue, and then infer from that a promise to be liable for the entire amount.
Well, I don't think the inference for being liable for the further amount is, send an invoice and a check will be sent upon receipt. Please ensure that any and all invoices are sent to my email address because of my travel schedule.
But that could just mean, look, my son is really bad at checking his email account, so if you send it to me, I'll get after him.
It could mean that, except that it says, upon receipt of an invoice, a check will be sent. It doesn't say, upon receipt, I'll work on my son to get a.
It also doesn't say, upon receipt, I'll send a check.
No, but he is the one that sent the email. An email has to come from a singular person, and he does use the phrase "our" and "we," but an email has to come from a singular person. And even if you're looking at "our" or "we," he's saying, we will pay you. Meaning, if my son doesn't, one of us has to. The only other person there would be me, would be Paul Muntjan.
One thing that I've had a little bit of a hard time with is, like, typically when you have a guarantor, the guarantor is not stepping in and paying right away. The idea is someone's going to pay. I'll promise if they don't pay, I'll pay. And so what seems to be happening here is just a father helping out a son who's got legal problems and saying, I'm used to this. I know how to deal with lawyers. Let me handle this. But never saying, and I'm taking, this is a debt that you'll incur, and then I'll also be contractually bound. If you don't pay it, I will. It's just a meddling father who's saying, let me handle this. And I'm just having trouble seeing how if we say this is enough in this case, that we're really kind of walking back what was expected in the statute of frauds for someone to say, I'm going to take on the role of a guarantor of some debt. So help me not be concerned here that this is quite a departure.
I think if you go back to the Fain case, where this court said, didn't say it, it cited with approval a different case that said a letter as simple as, I will be responsible for whatever debts my son makes, constituted an ongoing guarantee. That's the 1920 language. I think what you have here is an email saying, send me an invoice and a check will be sent. There is not the specific language of the promise to pay, but it's also not just, my son's it's not the conversation between, again, the father and the son saying, look, I know you can't pay for this, so I'll do it. Just have them send me the invoices and I'll pay it. We're not resting on the course of performance of these invoices were sent out to Nick and credit card payments came back from Paul, and therefore that's the guarantee that we're trying to enforce. It was based on the specific, the oral promise at the beginning, but then memorialized by this particular email and the rest that said, send me the invoice, a check will be sent.
Couldn't you have just sent a response saying, so Paul, to confirm, you will take responsibility for these payments, something like that?
Again, this is a little bit outside the record, and I can answer that question as to why.
I know it's hindsight. Yeah.
I'm sorry?
I know it's hindsight, but...
Well, it's not just hindsight. At the time, the fact that the engagement agreement hadn't been signed, had gotten lost. It was, the record is clear that there was an initial meeting in August. Nick then called and said, hang on, don't do anything yet. We don't need to do anything. About 3-4 weeks later, he did, and that was when things kind of started moving, and the fact that the engagement agreement had never been returned was overlooked. I'll put it that way. And so the reason that email wasn't ever sent saying, can you please confirm this, was because the understanding or the assumption was that the firm had already had something in writing.
It does seem, though, that in order to interpret this email the way you're suggesting, we have to sort of make some inferences based on facts that aren't in the email. And I say that because if this were written, if Nick had an accountant who was helping him with his books, and the accountant sent this email, you wouldn't be saying that the accountant was guaranteeing the debt, right? I mean, and an accountant could say these things. It's important to us to always pay our bills, and when you send an invoice, it'll be turned around immediately. But you wouldn't say that evidenced the accountant's guarantee of the debt.
No, I wouldn't, Your Honor, but I think the difference there is the accountant is clearly the agent for either Nick or the business. Paul is not his son's agent by any stretch of the imagination. And so, yes, does it require an inference? Yes, it does, because again, the words, I promise to pay my son's debts are not clearly laid out.
And so if it requires that kind of inference, does it satisfy the statute of frauds?
I think it does, because I think even with that inference, there is a clear, again, a manifestation of the intent that Paul was going to pay these bills. Paul was going to pay these debts. I believe I've already touched on the issue with regard to a continuing guarantee versus kind of the one-time guarantee. But again, I'll just note that here the writing specifically references the future invoices, and again the parties' course of dealing, where Paul was asking about payments made and payments missed, and making sure that the account was reconciled clearly indicates that this was a continuing guarantee. We think the only logical reading of Paul's email is that it's a manifestation of his intent to bind himself to pay his son's legal bills, and therefore we submit that the majority below erred in concluding that it did not satisfy the statute of frauds. We therefore ask that the Court of Appeals decision be reversed, and if the court does not have any other questions for me at the moment, I will reserve the rest of my time.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
May it please the court, my name is Mark Hayes, and I represent the defendant appellee, Paul Muntjan. If I have learned one thing in 24 years of marriage, it is that one person can be certain that they said something, and the other person in the room can be certain that they didn't say it. And yet, both people, if you continue to be married, will eventually conclude that neither person is lying. How is that possible? Because we have expectations, we have what we expect, what we think is reasonable, we make a meaning. And then after we make that meaning, we can actually kind of form our memories as to what was said. And I think really that's what happened here. I don't think anyone is contending that anyone is being purposely dishonest. I believe Mr. Saint-Sing believes that that was said, that Mr. Muntjan said he would guarantee the debt, and I believe Mr. Muntjan when he completely denies it. So how do we resolve that discrepancy? Well, the statute of frauds allows us to do it in this particular situation where confusion is really going to pop up more often than just with an original promise. With an original promise, the performance itself kind of substantiates that there was a meeting of the minds. If I say, you know, come paint my house and I'll pay you, the fact that you come and paint my house, that means, you know, you believed that I had asked you to do that. With a collateral promise, you may still come paint my house because my neighbor hired, or paint my neighbor's house because my neighbor hired you. But whether there was a collateral promise to kind of backstop that payment, we can't imply from the performance. So that's why it falls into the statute of frauds.
Would you concede that it's possible to read this email, the September 23rd email, in a way that's completely consistent with the plaintiff's interpretation?
It depends on what you mean by.
In other words, nothing in this email contradicts the plaintiff's contention that Paul agreed to pay and.
Right. I think what you're getting at, I think, and correct me if I'm wrong, is as parole evidence, would this necessarily thwart their inference that there was a contract? I don't necessarily think that it would, but that's not what we're using these emails as. The law clearly says you have to have on a piece of paper the elements of these contracts. I should be able to look at the pieces of paper. And so what are those pieces of paper? There's the engagement letter, which nobody signs and I think got lost. Mr. Muntjan said he didn't even actually get it, so that's kind of neither here nor there. It doesn't say anything that Mr. Muntjan agreed to do anyway. There are the invoices that follow all of Mr. Muntjan's emails, so obviously they weren't drafted by Mr. Muntjan, and he can't have even incorporated them because they didn't exist until after his email. So that just leaves us with the 5 emails. So these emails, the 5 exhibits, we have to locate the elements of a contract on there. Now, as we read this, is this consistent with just an inference that maybe there is a contract somewhere out there? Could be. I don't deny that. That inferences could go both ways. But that's not the standard here. You may have seen these custom puzzles that they can make, where you can send a picture in, they'll make a puzzle for you. Imagine somebody made a puzzle for me like that, and I start putting it together, and I see my own face, and I see my wife's face, and I start seeing a room that we're in, and I see one of my children's faces, and I might think, oh, the puzzle may be half done, and I may think, this is going to be a picture of my family. But until I have a piece with every face of my 5 children on there, I don't know if it's a picture of my family or not. It may be missing an essential element of my family, say my 3rd son, Connor, right? So we have to identify what are the essential elements, what are the pieces of paper that we can look at, and do we see on those pieces of paper the essential elements? So the question here turns to, what is there a promise somewhere? Well, just starting with common sense, a promise is going to be some sort of statement of, I promise to, some sort of I action. One thing that these emails are noticeably devoid of are I statements. There's only one I statement in all of these emails, and it's when Mr. Muntjan says, I'm attaching something to this email. He never says, I will do this, that, and the other, much less I promise I will do this, that, and the other, right? So at the beginning, we don't even have really the stem of a promise. I promised, I action verb, right? We don't have that. Also, a promise doesn't make any sense unless it has some sort of object. If you go to a wedding and the groom says, I promise to, and just kind of trails off, that's not a promise, right? It has to be a promise to do something. So what is being promised here? The promise, remember the contract, even though there's the underlying contract for legal services, the contract here between the firm and supposedly Mr. Muntjan is a guarantee, right? And I think this goes to what Justice Dietz was talking about. When we look at these emails, if we read them on a blank slate without this parole evidence, all this context, and we said, what kind of contract is this? Not only do we not have the most direct, I will pay if Nick can't pay, we don't even have Nick might not be able to pay. We don't even have kind of a conditioned precedent, like that may happen, and therefore don't worry about it. So we're looking for an essential element of a promise to backstop a payment. We don't have any hint that a backstop will be needed, that it exists, much less that Mr. Muntjan will do it.
What do we do with the factual finding made by the trial court that there was in fact an oral promise? I mean, you used the catchy metaphor at the beginning of when your 2 spouses have different expectations and they reasonably disagree. I sent you the receipt for the dry cleaning. You said, got it, and then you didn't bring home the dry cleaning. But here there's a judge listening to both sides, and the stories might have differed, but someone said there was an actual agreement, and we're looking under the statute at whether the memorandums support the existence of that agreement as oral agreement as found as a matter of fact by the trial court.
Right. Well, so 2 things. First, let's just assume for a moment that there was an oral agreement. To satisfy the statute of frauds, at minimum, you're going to have to memorialize that. You're going to have to refer back to it and say, okay, here's what was said, right? These emails, they don't mention it at all. If you read just these emails in a vacuum, you wouldn't know that there was a conference beforehand. You wouldn't know that there was any oral agreement, not that that would be binding anyway, but it's not like it says, it's not that the contract has to be executed on paper. It can be a memorialization, but when it does that, it has to hit all of the elements. It has to memorialize those elements. So I think that's the first part. The second part of it is this is a collateral promise situation. And like with land, it's a weird, special situation where we're removing it from just regular civil litigation where the fact finder just weighs the credibility of witnesses, because it's such a ripe situation, not just for perhaps fraud, but I think has happened in this case, which is just mutual misunderstanding. Like there just never was the meeting of the mind. And the way that the statute of frauds cuts through that is it puts it in writing. And the reason it does that is not as a procedural nicety, it's actually to get clarity so that we know, like, was this agreed to or not? We should be able to look at the black and white on the pieces of paper and tell.
So why would your client care about corrected invoices in one of the emails, or about capping how much would be charged for responding to discovery in another email, and making various payments on his credit card.
Those are all, you know, if this was a mystery show, those are all clues that would sleuth us toward thinking that there's a contract somewhere. But that doesn't say that it's on the page. That's the standard, right? And there's also, of course, evidence on the other side. If Smith Debnam believed that there was an agreement at that initial meeting, why didn't they follow up on the signed fee agreement? Why did they exclusively send invoices to Nick? Repeatedly, they sent them to Nick, just one after the other, always addressed to him, never to Paul.
But eventually, your client asked him to do otherwise, to send copies.
Actually, eventually, I think Nick actually was the one who asked. But regardless, somebody asked at some point to start getting copies on it. Mr. Muntjan asked in December, copy me on it. Smith Debnam didn't do it. 6 months later, Nick asked again, and then they started copying him.
Well, here's the one in September, signed by your client, that says, as a reminder, please ensure any and all invoices are sent to my email.
Right.
Due to my travel schedule.
He does make that request, but they didn't do it for 6 months, is my understanding. I don't think they did it until Nick pinged them about it in June of the next summer. But regardless, there is parole evidence that maybe there's a contract out there in the ethos. I'm not saying there's not. And if this was just a mystery show, then we would follow those clues and try to figure out, is there one? But the statute of fraud says you have to be able to identify the pieces of it, the composing pieces of it. If you can't put your finger on it, then it's just like that puzzle where there's a piece in the middle, and I think because the other 4 brothers are in that picture, that my 5th son is probably the missing piece. I think that. It might be a rational thing to infer. But the statute of frauds doesn't say use writing to muddle out whether this is true. The statute of frauds says use writing to establish each essential piece. And just like
I'd like to follow up on Justice Riggs' question about the finding of fact in the contract. I don't say original contract because there's an original promise. I don't want to be misunderstood. And so I'm hearing you say that the fact that there was that finding of fact, given that there's a guarantee here, it does not carry the same weight as it would in an ordinary case. Am I understanding you correctly?
I think what would be clearer of my position is that it doesn't matter here, and that we would deal with this case a different way if it were a different case, an original promise case, and a finding of an oral contract would have meaning. It doesn't have any meaning here because it's a collateral promise case. You have to comply with the statute of frauds because these collateral promise situations are ripe with confusion, unlike an original promise where the performance itself kind of supports that there was a meeting of the minds.
I read the dissent argument that all that's required is a memoranda, and since we have a finding of fact of that first promise, is it your position that it's necessary that the guarantee also contain all the elements that would have been in that contract, notwithstanding there's a finding of fact that there was an oral promise? Or I might ask the question this way: are you stating that the first promise was subject to the statute of frauds and had to be in writing to be enforceable?
I think there's a lot. It's hard to trace out the different possible theories of contract here. And I asked that question in my brief to opposing, saying, if there was a contract, there should be a crystallized moment that there was a contract. And I didn't get an answer in their reply brief when that moment was. So I'm kind of playing with a bunch of different possible
So are
scenarios.
you challenging the finding of fact of the trial court, that there
No.
was
They found an oral finding of fact. It doesn't matter because
And so does it really matter whether there was a crystallized moment if we have a finding of fact for which we're bound?
well, so it depends on what theory they're proceeding on. If
Well, and here's the thing, sir. We've got to figure that out, so would you please present us a theory that we can use?
Sure. I'm saying that there was evidence from which a judge could conclude that an oral agreement happened. I cannot contest that. Obviously, I disagree with it as a matter of fact, but I can't contest that finding is supported. I cannot challenge that finding on appeal. However, I can say it doesn't matter because it has to be, the elements have to be reduced to writing. And we don't have here even a
Okay,
writing.
let me stop you because I want to make sure I'm following. When you say the elements have to be reduced to writing in the guarantee or in the first contract or the contract?
When you say the contract, Your Honor, if I could just ask.
I'm talking about the finding of fact contract, the contract that would, had they signed the agreement that was sent and lost, that would have been the contract, and that would have been in writing. So my question to you is, what is it you're saying has to be in writing specifically if the contract supporting all of this, not the guarantee, is not subject to the statute of frauds, and we do have a finding of fact that there was an oral contract? Let me ask it this way. Why is it, if we do have that contract, why were the memoranda as represented by this email and then other emails later that were a continuing, as your friend is arguing, potentially a continuation of that guarantee? Why would that not be sufficient?
Well, I think first, this never mentions the original supposed oral contract at all, none of these emails. So there's no connection there. We don't even have anything in these emails that says, hey, remember that meeting. I mean, it doesn't even say, there was a contract. It doesn't even say that, which wouldn't be sufficient because it would have to say, here are the elements that we meted out. So ultimately, the answers with all of, and there are a lot of contracts here. There's the oral contract, there's the contract for the actual representation, there's the supposed guarantee contract. So I understand it's very confusing. But really, their recovery theory is exclusively on, did Mr. Muntjan guarantee to backstop those payments? We're looking only at the writings that are relevant here. It's just these 5 emails. Is there anything in those emails? Like if you looked at it at a blank slate without all this parole evidence and tried to deduce, if you gave it to somebody who'd never seen these 5 emails, what is happening here? There's no way you would come up with a guarantee contract. It just simply doesn't say it. It doesn't even present the facts from which one would infer someone might want to do a guarantee contract.
So how do you interpret, or how should we interpret, it is important to us to always pay our valued partners quickly for their services rendered, so rest assured your invoice will be turned around immediately and a check sent upon receipt.
I mean, it's probably a vouching, perhaps, or maybe it's just a declaration of this is important, or, it could be really anything. It could be an indication that, well, I guess it's more relevant. What is it not? Is it a promise? I mean, that's the only question that turns here. Is it a promise? Is this a statement, I will? We have a complete absence of the I, or, I, Paul, will do this. There's no, this will happen. It's just a declaration of importance because something is.
Importance to whom?
Importance to us.
And our. Who are the us and our?
I would presume that the us and our are Mr. Muntjan, his son, and the company. He certainly doesn't speak for the company. It could be any of those. It's ambiguous to try to deduce what's happening there, but what is clear is that it's not a promise. It's not Paul saying, I'm on the hook for this.
But when you look at, so rest assured your invoice will be turned around immediately and a check sent upon receipt, 2 questions out of that. How can he know if he's not himself saying, I am backstopping this? How did he know to make that statement? And, a check, I understand it was actually credit card payment. Why does receiving the credit card payment not underscore that it is us, my son, his company, and me, but oh, by the way, I'm the one who's backstopping this?
Again, I think that's parole evidence that there may be an agreement of some kind. There is evidence both ways on that. I'm not saying that if you were just trying to figure out, whether they had some sort of agreement, but that's not what we're doing. We're trying to figure out whether there's an agreement that was reduced to writing. And there's no, this will happen. is important. He says it will turn around. Maybe he's just blowing smoke. Maybe he's vouching for Nick. We don't know, but he
Then when
definitely,
they received a payment
right,
from him,
right.
why does that not just validate? Because the payment itself is a writing.
I don't know the answer to that question, if the payment itself is a writing.
On a credit card, you get a receipt.
Right, but it would have to be signed, I believe. Anyway,
Either authorizing the credit card to be used.
right, I don't know that an authorization for something to happen, I think that would be a thing that happened, but regardless.
I think my credit card company would be surprised.
Well, think of it this way, I think. This is probably a better way to think of it. If it's a contract, right? Let's assume for a second that it is. It's a contract. If it's a contract, it's a
May I have a clarification? When you say it's a contract, are you talking about the guarantee?
the guarantee, the
All right,
guarantee.
and so let me ask this question. My reading of the exceptions to the statute of frauds is not that it has to be a contract, but it has to be the promise for the debt of another, to pay the debt of another, a promise, which would not be a contract. A contract, as you know, is offer, acceptance, consideration, and all the other factors.
Right.
And so I'm really grappling with the fact that you appear, or at least I'm hearing that you're arguing, that guarantee has to rise to the level of a contract to be a guarantee, and that's not my understanding of what a guarantee is.
Right. I will let Mr. Davies comment on that. I believe from his brief, he also says it's a contract. I know I have read case law, and I apologize, but if you will look for cases on consideration for a guarantee, you will find those cases.
And certainly, if that were the case, but what we're really talking about is just whether there was a promise to pay the debt of another.
Right, but there has to be, if that is not a contract, then there's no breach of contract. They're collecting under a theory where there was a breach of a guarantee contract. And if that is true, those obligations have to go both ways, right? So if they go both ways, imagine that the facts of this case were upside down. So Mr. Muntjan said, I will backstop this representation. And you, in exchange, are going to continue the representation because, because of that guarantee, even though maybe you would feel nervous about getting paid. They would have an agreement. Let's say then that Smith Debnam dropped Nick. Let's say they dropped him. Could Mr. Muntjan say, just based on these emails, you breached my contract. I gave you consideration, this guarantee. You walked away. You broke the contract. Is there any way, looking at these emails, that you would say Smith Debnam was on the hook? They would certainly point to their engagement letter and say, hey, we sent that out. It was never signed. We were never on the hook for this, right? That has to work both ways. If Smith Debnam is off the hook, if Mr. Muntjan sued them, he is off the hook when they sue him. Because these just don't evidence a promise. It's just not there.
I'd like to go back to some of the language that the Chief Justice was highlighting. That second sentence in the September 23rd email, it is important to us to always pay our valued partners. So the our is Nick and Paul, right? Talking about partners of Nick and Paul, right?
And perhaps the company.
Quickly for their services rendered. You don't dispute that there he's talking about paying their partners pursuant to agreements, do you?
I don't know.
Well, there's if we're going to allow some degree of informality,
Right.
don't you think that the average person looking at that language that's how they'd interpret it? Start paying you for services rendered, that probably means pursuant to some agreement?
That makes sense, yeah.
Okay, and so then it's so, which I think there means therefore. Do you disagree with that? Therefore, rest assured, right?
I'm not sure where you're going, but perhaps, I don't know. I haven't reflected on this as if this is written like a contract because it's written as an email.
In other words, if you turn this into sort of like an if-then statement.
Right.
All right. It's important to us to pay our valued partners quickly for their services. So rest assured, you will be paid. Mm-hmm. Doesn't that mean you're one of our valued partners? You're in that category of people we pay for services rendered.
Right.
To us.
I think you could make that inference, and the question, though, is he saying he is personally on the hook, and he never uses the word I. And I welcome your close textual reading of this text. You're reading it like a contract, because that's what it has to be. Because there was never a signed agreement, this is all we've got. Not all the context and all that stuff. We've got to be able to find on here language that says a promise. And if you ask anybody, what's a promise? Give me an example of how you would start a sentence if you were going to give a promise. It would be, I will, I promise, I shall. It would be something like that, which we don't see. Examine this as the contract, because that's what it has to be. We don't have that language. One final thought, actually. There was a point early on in Mr. Davies' argument about being bound. When we see in the statements in these emails, do we see an intent to be bound? Not just to say, I hope that will happen. It's important for that to happen. We will make that happen, if he says that, which he really doesn't. But is he bound by it? I pledge to do it. I promise to do it. I will do it. I'll be a liar if it doesn't happen. Would you call him a liar? If he got this email and it didn't, would you call him a liar? Anyway, finally, I just want to point to one kind of procedural point. The Court of Appeals, we reached this decision, or this point in the case, because the Court of Appeals said, we will assume without deciding that a valid contract formed. We raised the issue that a valid contract didn't form because there wasn't a meeting on terms. What were they talking about? And this is not just an academic point. In that initial meeting, they were talking about, we could represent you in negotiations to make this lawsuit go away before it gets to litigation. And so there was a difference of opinion there. So it is certainly possible that Smith-Debnam could say, yes, there was a contract, but it's not a collectible contract here for these invoices, which are the litigation invoices. So the Court of Appeals never reached that issue. They just assumed arguendo and skipped over it. So even if this court found that there was a promise of something, there would have to be remand to see whether there was a meeting of minds to form the theory of a contract under which the invoices were collected upon, which is, I'm agreeing that you're going to represent for litigation, and I will backstop that litigation work. With no further questions, I'll take my seat.
Thank you, counsel. Rebuttal.
Thank you. If I may begin by going to the last point that was made. The Court of Appeals seems to have conflated kind of two different worlds, one of an original promise and two of a collateral promise. And a lot of the analysis with regard to whether there was a contract, whether there was a meeting of the minds, in my opinion, relates more to whether there was an original promise by anybody to engage the law firm for the services. So all the analysis about whether they agreed on the price, the work to be done, I think that's basically irrelevant for the question of a guarantee. Because to your point, Justice Berenger, a guarantee is a separate contract from the original contract. And all that's required of a guarantee contract is, I will pay those debts. There is a finding of fact, I believe it's number 8, I may have that wrong, that neither Paul nor Nick disputed the amount of the invoices or that the work was done. So with regard to the guarantee, if the guarantee is a guarantee of the debt of Nick, and Nick doesn't dispute the debt, then there's no basis for needing to find whether Paul agreed to the terms of the agreement between Smith-Debnam and Nick. He just agreed to pay those debts. And I think that also goes to your point of what is the contract we're talking about. Originally, at trial, the contract we were talking about was, we made the argument that this was an original promise from Paul, from Nick, from the company. The Court of Appeals determined that it was not. And so now we're making the argument, as we did kind of in the alternative at trial, that even if this falls within the statute of frauds, these emails satisfy it. And with regard to the lack of I terms, looking at Mr. Muntjan's email, he doesn't even start it with I. He says, received your email. Well, only one person could have received that email, so the I is implied. I received your email as addressed to son Nick. With regard to whether the elements of a guarantee are contained within that contract, as I understand it, a guarantee requires three things: the identification of a debtor, the identification of a debt, and the promise to pay. That email starts off with, received your email as addressed to son Nick. That's the identification of the debtor. Requesting prompt payment. That's the debt. And then, yes, you have to do some putting pieces of a puzzle together to get there, but when you read it, it says, again, taken a little bit out of order, send me invoices. Send me the invoices. Send me any and all invoices. When invoices are received, payment will be sent upon receipt. So you've got one person sending that email saying, send me the invoices, and when invoices are received, payment will be sent immediately. The only way that email makes logical sense is if Paul is the one that is paying and agreeing to pay those debts.
But he does use the passive voice for the will be paid, and so that's what I'm wrestling with. Are we allowed to look over the fact that he used the passive voice, it will be paid, instead of saying who will pay it? Are we allowed to look over that, or is that fatal here? Because he could have just as easily, using the passive voice, he could have meant, my son's going to pay it. Because it just says it will be paid. It doesn't say who will pay it.
Yes, I don't think it's fatal, because again, this email can only come from one person, and the only person that can ensure that a payment is sent upon receipt is the person sending the email. He can't ensure that somebody else will send a payment upon receipt, particularly when he then asks that the invoices be sent to him. If an invoice is going to pay immediately upon receipt, and I ask it to be sent to me, the only way it can possibly be paid upon my receipt of it is if I pay it.
But so if the email said everything it says, except instead of payment will be sent, it said Nick will send you the payment, then this would not be a guarantee.
I think that's completely different. I think that's the Fain case where he's vouching for Nick's creditworthiness, saying, yes, please go ahead and extend credit to this person because I think they're good for it. That's that kind of other side of the scale of, that's not a guarantee. That's saying I think he's good for it. That's not saying it, again, he doesn't use the word I ever. I wish he had. But in order for it to be paid upon receipt, if he's the one getting it, he has to be the one paying it.
What could the father have said in the emails in order to get the invoices and pay them because he wants to help his son, who he knows is terrible at this stuff, and it's lawyers and it's an important lawsuit, and he wants to make sure his son's doing everything right, without becoming a guarantor?
Well, I think Justice Earle's language would do that very well. Send me the invoice. I'm trying to keep track of things. I'll make sure Nick pays it.
But no, the father's going to pay for the son's bills. He doesn't want to become a guarantor. He's just saying, I know my son is really bad at paying bills. I don't want to get him in trouble, so I'll pay for him. But I don't want to become contractually obligated to cover all the expenses. I just want to pay here. What could you say, given your interpretation of this language, that wouldn't end up with everyone that does that becoming a guarantor?
Well, I don't know. Honestly, I'm not sure how to answer that question, because I think that language would make him a guarantor. If you're saying, send me these things and I'll pay for them, I think you are becoming a guarantor of that debt. I think if you say, the testimony at trial was that this was a loan. If it was, if that was what was intended, and you wanted to avoid the possibility of it being considered a guarantee, you say, I'll pay this as a loan to Nick, or something along those lines.
I was puzzled by your response to Justice Earle's, because it seemed to me your argument is, well, he uses the passive voice to say your invoice will be paid, but he must mean himself because he's the only one who can ensure that that happens. But if he could But yet you seem to entertain the hypothetical that he could write, Nick will pay. Well, if he can't ensure that anyone else pays other than himself, then how could he say Nick will pay?
Well, I don't think he could say Nick will pay and have it have actual meaning. He could say, I'll try to make sure Nick pays, or I'll make sure Nick pays, something along those lines. And that's, whoever's reading that would naturally understand that, I mean, he can't force anybody to do anything.
So the real problem, I think, at least in my mind, with this email is it could mean Paul's going to pay, but it could also reasonably mean Nick is going to pay. And so that's what I'm struggling with. I see ambiguity there, and so I have a hard time seeing the clear manifestation that's required.
I understand the hesitation. I think it's reading it all together. When he says, send me any and all invoices, take that language. Take the language of, once we get an invoice, we'll pay it. The only way that makes sense is if he's the one paying it. Send me an invoice and it will be paid upon receipt. The only way that makes sense is if he's the one paying it. He can't, Nick can't simultaneously pay something when Paul gets it unless, it's routed to him. And the only logical reading of that email is, send me the invoice, it'll be paid upon receipt. Yes, it's an inference, but the piece there is, who's going to pay it if I'm the one receiving it and it's being paid upon receipt? The only person that could pay it is me, is Paul. If there are no further questions, again, we'd ask that the Court of Appeals be reversed, the judgment of the trial court be reinstated, and thank you very much.
Counsel?